Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So, we received an interesting inquiry here on our YouTube channel. This has to do with somebody who was accused after being mugged. Accused of what? Let's see here. I'm 45 years old. A young man of 16 assaulted me. I defended myself, then I was arrested for battery. Okay, so here's the deal. First of all, let's talk about battery. Battery is just a harmful or offensive touching. Here in the state of California, that's a misdemeanor that carries up to 6 months in the county jail. It's not the worst crime. Usually these things can be reduced to maybe, they could be reduced to something like, 415 of the penal code, which would be disturbing the peace. But the thing is this, there needs to be a fine line. There needs to be a fine line, and there is a fine line between self-defense and revenge. Let me explain. Let's say the 16-year-old kid attacked you. All right? You have the right to physically defend yourself when you're being attacked, when you're in the process of being attacked. But you're only allowed to use the minimal force necessary to avoid suffering additional harm. Obviously, if somebody attacks you, with a knife or a gun, you have the right to use deadly force to defend yourself. That's absolutely true. However, what you don't have the right to do, is to keep going, to keep whacking him after he can no longer defend himself. Let's say the 16-year-old attacks you, he starts punching you a couple of times, you punch him back, and then he gets hurt. Okay, at that point, the fight needs to stop. You can't keep hitting him. But because you're upset, if you get him hurt, and then now you're dominating him, and he can't defend himself from you, and you keep whacking him, he gets on the, he falls on the floor, and you start kicking him, or you give him, whatever. Well, at that point now you're the new aggressor, and if he gets really hurt, they could even charge you with a felony 243, which would be battery causing great bodily injury, which would carry up to 3 years state prison. So you have to understand it's a very, very, very fine line. You can only use the minimal force necessary. The minimal force necessary to defend yourself. And this is something that always gets a lot of people. Let's say somebody punches you in the face and then runs off. You don't have the right to chase him to hit him back. Legally, you don't have the right to chase him to hit him back because he's running away from you. The danger's finished. Now, if you saw the punch coming before he hit you, yeah, you could have hit him then. But if he punches you and runs off, can't chase him to hit him back. Can't do it. You just need to call the police and say, I got punched. I mean, really, you just can't do that. California. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates. Remember, here in the state of California, we don't have stand your ground laws. But if you've been accused of a crime and need representation in court, give us a call at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who got accused of destroying other people's property. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.